case for DV, which had closed, and there were indications that father could not control his anger. So it's one of those cases where I don't know that I necessarily would have been. Just leave it at that. I think that was a San Diego case too, so I'm not trying to put anyone here in the hot seat. The next one, NRACQ, is a restraining order case. And I believe this one was out of LA or Orange County. Thank you. Domestic violence between mom and dad in front of the kids. The court entered a permanent restraining order prohibiting father from contacting the children outside of the monitored visitation. The father appealed not only the restraining order, I think the dispo orders as well. The Court of Appeal reversed on the restraining order. These were somewhat older kids. They were verbal kids, and they were telling their attorney, I'm not scared of dad. I want to visit dad. I don't know about the domestic violence, but I really love my dad, and I want to have, ongoing contact with him. And so what the Court of Appeal reasoned was there was no evidence that the children's safety was in jeopardy. Without including them on this restraining order, the father was to stay away from the family home. The mother was not to monitor his visitation. The children weren't afraid of him. So there were other court orders and protections in place such that the kids did not need to be included in the restraining order. So it's something to consider, because I know we have a lot of restraining orders going around in this courthouse, as to whether or not the children really need to be included in the 3-year permanent restraining order if there's really no showing that they are going to be at risk if they're not included on that restraining. Okay, the other big topic in 2013 was sex abuse. And I put on this slide, I happened to be in 411 one day, and one of their county councils, who gets very passionate when he argues, looks at Draper and goes, the Supreme Court and IJ finally put to rest there, and he points down council table, Rubel-Sella E argument. And Judge Draper, if you've ever been in front of him, is very calm and looks at him and goes, that's not actually what it says. I want all of you to know why Judge Draper said that and be able to make the same response to your county council. Because IJ in no way overruled, overturned, or superseded Rubel-Sella E at all. And the best way to know that is to read it. But in case you don't have time today, I will give you the synopsis. This was a pretty bad sex abuse case. The father fondled, digitally penetrated, and forcibly raped his daughter. And the trial court sustained the sexual abuse counts and found all children, including the 3 boys, to be dependents of the court. Our Court of Appeal divided on whether jurisdiction was proper as to the boys, and the Supreme Court granted review because we do have, Rubel-Sella E is just probably one of the earliest in a long line of cases, and you could draw a chart on, yes, they should be dependent, the boys should be dependent, no, they shouldn't, in all these cases because they're all over the board, and you can find 3 to 4 cases supporting your opinion and 3 to 4 cases that say you're out of luck. The key to NRAIG is they considered whether jurisdiction was proper over the boys under subdivision J. They didn't talk about whether or not a D was sustained against the boys or whether it should have been. The sole issue before the Supreme Court was the J count and whether these boys could have been found dependents under J. And they said basically subdivision J does not require the court to find that the boys would be abused or neglected as defined in the same subdivision as the sibling. Meaning, the trial court did not have to find that these boys were at risk of being sexually abused. They only needed to find that there was a substantial risk that they would be abused or neglected under any subdivision of Section 300. And that's the difference. The court, to sustain a J, does not need to find on a sexual abuse case that of the other siblings, boys, half-siblings, whatever, are at risk of sexual abuse. They can find that they're, substantial risk of physical harm under a B. It can be any of those subdivisions. They also said the serious and prolonged nature of father's sexual abuse of his daughter under these circumstances supports the juvenile court's finding that the risk was substantial as to all the children. The next slide is why Judge Draper said what he said. This is straight out of the case. We are not holding that the juvenile court is compelled as a matter of law to assume jurisdiction over all of the children whenever one child is sexually abused. So if you take one part out of NRAIG, it's that one. Because county council, I'll tell you, for the most part, has not read this case. I don't know what synopsis went out to county council, but somehow they're under the mistaken impression that, woohoo, we get all the kids in a decount. And that's not, in fact, IJ says the opposite, that there's no requirement that the court sustain as to all the kids. Alexis A came out after IJ. The father molested an unrelated girl by fondling her, rubbing his erect penis against her. The incidents occurred in the family home. The boys were present during the incidents, although they were unaware. I think the family was babysitting this girl. And the trial court found that father, son were persons described by B and D. The Court of Appeal reversed. So here's a good illustration of how IJ has come into play, because again, Alexis A followed the Supreme Court's decision in IJ. The Court of Appeal in Alexis A noted that the circumstances in IJ were more severe. In Alexis A, we had the family used to babysit like a 12 or 13-year-old girl, and the father molested this girl. I'm not saying that's okay. But the sexual abuse in IJ was over a more prolonged period of time. It was more egregious sexual conduct. The father had forcibly raped his daughter. And it constituted, it's interesting, and I took this language right out of Alexis A. The way that they described the conduct in IJ was that it constituted abandonment and circumvention of the parental role. So they really hinged on, in IJ, we're dealing with a father and his severe sexual abuse of his own child. In Alexis A, we're dealing with an unrelated kid. So all of you who email Danielle and I all the time and say, can we get a case that says a man's far less likely to molest his own children than his stepchildren, which we will never get, by the way. This is probably the closest we can come. And it's this language about abandonment and circumvention of the parental role. The Court of Appeal, the department was all over sex abuse cases this year. The first one was LA County versus Superior Court. The department took it up on writ after the court dismissed the sexual abuse petition. I believe this was Bornstein when he was on the bench in 412. The father had abused the elder half-sister over a period of years, which had ended 6 years before the petition was filed. And the Court of Appeal granted the writ and ordered the trial court to sustain the petition. Here's the thing. Here's some of the facts to kind of help you figure out where the Court of Appeal went. The mother had installed locks to keep the father out of the half-sibling's room. Father had done no rehab programs, no counseling, no nothing. And father and mother were now separated, which the Court of Appeal kind of honed in on, saying, well, now there's a greater risk because mom's not around to protect these children anymore. So now these kids are having, visitation with their father. Mom's not there, so clearly he's going to take advantage and sexually abuse them. And they did say that the trial court erroneously concluded that father was less likely to molest his own biological daughter. Okay, so there goes that argument. I think a lot of this is the issue of the no rehabilitative programs, and you'd probably have to look at that case in comparison with your own to see if there's other ways you can distinguish it. N. Ray Ricky T. Was a legal guardian who was also the maternal grandfather. He sexually abused his step-granddaughter. He was the legal guardian of his 3-year-old grandson. So when the petition came in, it was filed against him as the legal guardian. The sexual abuse in that case was brazen. They ran one of these carts in the mall, and he would bring her with him to work and put a blanket over her and do his thing, fondling her under it. The sexual abuse was brazen. It occurred in and out of the home. The family were like, no. Grandpa would never do that. But Grandpa was criminally convicted, but they made a mistake. And the child who was the subject of the petition was autistic, and particularly No, not the kid that was molested. So they I think they upheld the findings of the court that there was appropriate jurisdiction over the 3-year-old grandson that the grandfather had legal guardianship over. The other LA County Superior Court one came out of Department 407. Court dismissed it being a D petition concerning the 2-year-old child, and the Court of Appeal reversed, again ordering the court to sustain it, which is problematic for many of us who have been in the Court of Appeal, because legally, the trial court is the trier of fact, and the Court of Appeal is not. And so when they issue these orders saying you have to sustain this, it just doesn't feel right. It's really not right. But I'm not about to tell the Court of Appeal that they can't do that. But in this particular case, they reversed the facts as they were detailed by the Court of Appeal. Was that father had been convicted of sexual crimes against minors 25 years prior. Good fact for us. Father had been committed as a sexually violent predator for 13 years. Bad fact. And that they did rely a lot on the presumption under 355.1 because father was required to register as a sex offender. So for all you new attorneys, when you have sex offender cases, the department can rely on 355.1 to shift the burden to us. Okay, so that was a lot of sex cases this year. Next section is incarcerated parents. We came back to the holdings of Henry SD and things that I think your supervisors have probably been hollering at you for years. And the first one was Henry No F. Mom was arrested in a mart raid. And then, and of course, the department filed B&G's count saying, well, you can't make a plan, you're incarcerated. Mother had identified 2 potential relatives who could care for the child, but, well, the department didn't like them. Because maternal grandmother, who was one of them, had a DCFS history and she had some old criminal convictions. The Court of Appeal reversed, of course, as they should, and restated that incarceration itself is insufficient to assert jurisdiction. So it's the same thing as NRASB and those line of cases that we have, that mere incarceration alone is not enough if on the day of the adjudication your client can say, yeah, I can make a plan. And that plan does not have to be approved by the department. It does not mean that grandma has to pass ASFA. It just means that she has to have the ability to make a plan, and then there's no B or G count. Maggie S. versus Superior Court was a similar case. The mother gave birth while incarcerated. She asked for the infant to be placed with either her parents or her brother. The department said, nah, let's go ahead and file a petition. And let's go ahead and, court said, yeah, let's go ahead and sustain that petition under B&G. The reason the department filed the petition is the person that the mother had proposed, and I'm sorry I didn't write down if it was a grandparent or an uncle, but had lost their foster care license earlier. So at one point, whoever she proposed had been a foster care parent, and then they, for undisclosed reasons is what the record says, she lost her license, and so the department says, well, you're not appropriate, we're gonna file a B&G against mom. Again, the Court of Appeal reversed and noted that mother's not required to demonstrate the suitability of the caretakers, only that she has a plan. Okay, so now we turn to, finally, just go reunification and no reunification. The first one, JA versus Superior Court. The child was detained during one of the review hearings. Father's FR was terminated, kid went to mom, then kid's removed from mom, and the department said that they did not want to offer family reunifications to father under 361.5B10 because he had FR terminated. The Court of Appeal reversed it because if you read the plain reading of B10, it says sibling or half siblings of the dependent child, not that child. So unless the siblings had been removed and father had failed to reunify, the department and the court couldn't get him under B10. I don't know if I'm making that clear because I see a lot of blank faces. Under B10, parent has to fail to reunify, but what B10 says is fail to reunify with siblings or half siblings. In this case, it was the same child that had been removed again. That father's family reunification services had been terminated. That child was removed again. So father gets FR because the statute specifically says it has to be for a sibling or half sibling. Okay. NRASB, for those of you who are not aware, I believe it was last January, being a registered sex offender now allows the department to recommend to the court that you be denied family reunification services. And this was the first published case that went up on this new 361.5 B16, which is the registration bypass. And father, I think, made a lot of different constitutional arguments. The statute cites a federal statute that does not exist. It basically cites to this federal provision that has not yet been implemented in California. So father's like, hey, how can I be required to register under this law if it doesn't apply to California? Then the Court of Appeals said, we don't like you because you are a sex offender. And said, it doesn't matter, because the legislative intent was to extend this bypass provision under B16 to people who are required to register in any jurisdiction, not just California. So we're going to go ahead and deny you FR. And by the way, there's no showing that offering FR is in the best interest of your child. So not a good year to be a dad, not a good year to be a sex offender. The next one is NRA AM, which is another one that is very, I can't think of the word. It's an interesting read, and I would probably recommend you read it because I'm not sure I'm going to really be able to make it clear for you about what happened in this very odd case. It was an e-petition. It was an infant with multiple bone fractures, and the e-petition was sustained. The mother was denied FR on the basis that that e-petition was sustained. And so then the mother came back, she did some programs, and she had separated from father. She had obtained a domestic violence restraining order. She sought therapy service in an effort to better understand the ill effects of my relationship with father. She did parenting. Mother was still at a loss to explain what happened to her child, although she noted father admitted he was alone with the child when one of his injuries occurred. So, mom files a 388 petition, basically saying, look, I've done all these things, now give me some FR. The court granted mom's 388 petition, ordered FR, and both the minor and the county took it up, and the Court of Appeal reversed. And they basically said that they're going to attach a different standard than your basic 388 standard when the parent is denied FR because of the E-count. Again, I told you I wasn't going to make it very clear. So, in order to give FR to a parent, it's not just the E-count. I believe it also, I think the statute also encompasses I-counts, F-counts, and that one B6, I think, that talks about severe physical abuse and severe sexual abuse. So anyone under 361.5C, where the burden switches to us, the court now requires clear and convincing evidence of best interest. They're going to hold, now under the 388, they're going to hold you to what 361.5C requires. Clear and convincing evidence of best interest. Services are likely to prevent re-abuse or continued neglect, or will be detrimental because of the positive attachment. And they want the worker to report whether reunification is likely to be successful. They're going to consider past history. They're going to consider drugs or alcohol. So a 388 petition in those scenarios where your client's been denied FR because of an E or an I, an F, or severe physical or severe sexual abuse, you're going to have to look at 361.5C and make sure in your 388 you're hitting those issues. Because unfortunately we are stuck with NRA AM that imposes a higher burden. And in fact, I was looking at 388 yesterday for a different issue, and I believe 388 may have been amended to include this language. And Danielle Back is nodding her head yes. So I'm hoping that I'm right. That 388 now talks about specific findings if you've been denied FR under one of the provisions of 361.5 and what you need to show under 361.5C in your 388. So if you have one of these, you might want to just talk to your supervisor and you're just getting ready to draft it. NRA TW, we go back to, let's take a break from that one for a minute and just talk about timelines. Always everyone's favorite subject. The petition was sustained, child placed with father. Petition sustained against father, child placed with mother. 387 petition filed, child removed from mother. Court said, yeah, I'll give you FR. And the child took it up basically saying, come on, 31 months? That's just too much. Let's get this kid adopted. And the Court of Appeals said no, that the family reunification timeline commenced at the filing of the 387 when the child was